appeal in the matter of Maranello Rosso Ltd and Lohomij BV and others.
Good morning, everyone. Good morning, Mr. Fenwick. As you'll see, we have an unusually arranged court, and my Lord Justice Arnold is on the screen for various reasons. This case is one which has had the potential to come off the rails in the last week or so in so many ways, so it's very nice to see you all here. Sorry. And I think whoever sits here usually has longer legs than me. I'm now in the right place. Thank you very much also for your timetable, which we've noted. We've also noted that the respondents have a great deal of time, 2/3 or so of the time, and we would press upon them that we would be very grateful if they would avoid any repetition of any kind, because it seems rather at the moment that it's rather imbalanced, and so we'd ask them to take that into consideration. The timetable also includes transcriber breaks, which we are very happy to accede to, and as you'll see, the transcribers are dealing with this matter, I think, from the live streaming, which is very helpful to have fewer people, I think, in court, given the prevalence of COVID. I've said too much, so over to you, Mr. Fenwick.
Thank you, my lady, my lord. In this matter, as you know, I appear for Maranello Rosso, the appellant, together with Mr. Chelmick and Mr. Rouhani. My learned friend, Mr. Colton, appears for the first and fourth respondents, Lohomij and Mr. Lumen. Mr. Gledhill and Mr. Butler appear for the Bonhams parties as the second, third, and sixth defendants. And then for Mr. Collins appears for the fifth defendants, late Mr. Brooks, represented by his estate. And my learned friends, Mr. Weeks and Mr. Trishlianin, I hope I pronounced that adequately, appear for Mr. McLean's seventh respondent. My lady, this is our appeal against a decision of His Honour Keyser, who gave summary judgment for the defendants on all claims apart from a small claim in conversion against Mr. Lumen. He did so after 4 days of argument in circumstances where there had been no disclosure, and in my respectful submission, what should have been a relatively narrowly confined application centered essentially on the question of whether the settlement agreement had effectively acted as a bar to any claims, including claims in dishonesty and conspiracy, arising before the settlement was signed, with some other more limited matters, into a massive inquiry and mini-trial in which the judge made very large numbers of findings of fact, many of which contradicted the evidence given with statements of truth by my client and his witnesses, and of which one can see by looking at a very few. Those were findings which were, in my submission, not open to the learned judge to make, and that really accentuates that the exercise which he was beguiled into carrying out by those 3 or so days of submissions by the defendants was one which led him into error. And so there is a central issue which I will be addressing you on, which is whether, in the circumstances of this case, the settlement agreement can stand to prevent a claim conspiracy, dishonest assistance, and or whether the principle of sharp practice, which the judge rightly found to exist, prevents the defendants from relying upon settlement agreement, even if on its true construction, in all circumstances, it would otherwise preclude a claim. So far as the law is concerned, there were a very large number of authorities cited to the learned judge, very many of which he cited during the course of his judgment. And so it's not so much a question of misunderstanding or of failing to grasp the correct law, but errors in its application, which we are concerned with here. Lady, it's in identifying how we best get to the core point of the settlement agreement, it is, I think, necessary to stand back and look at some of the background and some of the findings made as to the background by the judge. I propose to take it relatively shortly. My aim is to look at this matter from above rather than descend into the weeds, because if we were in the weeds, we'd be here for a week, and it's not really going to help the exercise that this court has to carry out.
Thank you for that, Mr. Fennick, and you can also assume that we've all done our pre-reading.
I'm grateful. In summary, at the time of the relevant events, my clients believed that they had found a better alternative, equally good, but better because Bonhams had a better name, way of disposing of the Maranello Rosso collection at no real risk to themselves, except as to the amount of profit they ultimately made. And I will make that good as we go through the documents. By a series of events, that expectation proved illusory. Firstly, because immediately before the signing of the agreement, at a time when my clients had only a few hours left in which to complete the purchase for which they had put down a $2 million deposit, the nature of the deal was transformed from a risk-transferring sale into a loan on very onerous terms with a large profit margin for Lohomij. A month later, their expectation that the sales would take place in England, around Goodwood, which was the best place, they were told or believed, for the sale, as a single collection, was transformed into taking 12 of the, I think, of the best cars, including a 250 GTO, which is apparently an extremely special car, to Quail Lodge in California to be sold without reserve. And that sale was, from their point of view, a disaster, the prices being less than they had been offered. That series of unfortunate events, with difficulties which I acknowledge in terms of the legal remedies available where contracts weren't entered into at the right time and were all separated, was resolved by a settlement agreement entered into at a time when my client was in default and therefore had limited options available. And I take issue with the learned judge's comment that these were parties of equal bargaining power. They weren't. It was a settlement which, in fact, settled all my client's claims against the Bonhams parties and the Lohomij parties, but settled none of their claims against him. So it was a very one-sided agreement, as we will see.
What about the 13 million fee?
The 13 million fee, which popped in at the last minute, was cancelled by Lohomij, yes.
Was that not part of the agreement then?
That was part of the settlement agreement, yes. So
Was it not part of the original agreement?
it was part of the agreement entered into on the 29th of May, having been imposed by Lohomij at that date.
Are you saying it wasn't? Are you saying it in some way wasn't a valid part of the agreement?
Well, no, it was a valid part of the agreement. I accept that.
So why didn't you gain a 13 million pound advantage?
It is quite a good gain, but it's effectively. I'm not saying they got no benefit from it. I'm saying that they were in a position where they had limited options open to them. And it was a claim which, as we'll see, was it was based on negligent breaches of duty, with elements asserting a conflict of interest on the part of Bonhams, but without, we'll submit, and we'll go through it, so I'm not going to take it in detail, without any allegations of fraud being made explicitly, or we say at all, and it was only much later that the reason for this claim came into the knowledge of my clients through a statement made by Mr. McLean. And I'm going to take you, because it's the easiest place to look at it quickly, if I may, in the supplemental bundle at tab 25, which is Mr. Sullivan's first witness statement, page 221. In paragraph 201, he says, as I previously mentioned, prior to entering into the settlement agreement, I had no idea that MRL had been the victim of conspiracy to defraud. I had no reason to think so. Yes, we'd been bullied. Yes, the auction had gone badly. It had no basis to think anything worse had taken place. In fact, the opposite, dealing with a highly reputable auction house and its owners and principals. No apparent reason why they would defraud us. We assumed all along they wanted what we wanted, to achieve the highest possible price. The first I knew we'd been the victim of fraud was when Mr. Hilder and I met Mr. McLean on 12th November 2017, Wilson Place Hotel in Guildford, around 5 p.m. He'd been let go by Bonhams about a year previously, then we, I think, just go down to 203. He told us they'd never intended to sell the collection at an auction in the UK. The plan had always been to sell some cars in the US in order to boost their presence in that market, thereby increase their value in preparation for the planned upcoming sale. He told us they knew that we wouldn't agree, so they lied to us. He told us the auction had been illegal. Mr. Brooks was terrified of the action. And the reason Lohomij became part of the settlement was so we could not sue them at a later date, to avoid Bonhams having to show a loss of 13.6 million in these accounts. So those are the key points. It's also echoed by Mr. Hilder in his witness statement, tab 27, page 234, paragraph W. So that, in my submission, is a very different thing to...
Can you give me that reference again?
Yes, of course. It's tab 27, paragraph 2, page 234, paragraph W. For some reason, these paragraphs are in letters rather than numbers.
7W.
No, just W. I don't. Or is it 7?
No, it's 7W.
You're,
Yes.
you're quite right. 7W. Yes. submission, a completely different complexion on what had happened, and a complexion which could not have been foreseen and was not foreseen by my clients when entering into the settlement agreement. Before we go to what the learned judge said in his factual narrative, which is relevant to this, can we just look at what documents show we'll have to come back to some of these.
Before you leave those paragraphs, can I just ask you this?
Yes.
The conspiracy is in these paragraphs referred to as a conspiracy to defraud, and the reference to being a victim of fraud. But I hadn't understood that that's your pleaded case. You don't plead a conspiracy to defraud, do you?
No, we plead an unlawful means conspiracy, but that's his wording of it. But the facts are that there was a conspiracy, effectively, to get hold of the cars and sell them differently to what they had said to us at Quail Lodge for their own purposes. But that was what Mr. McLean said. One has to look in the light of that to what actually happened, which we can see by going back in that same volume to tab 3, page 5. And this is the letter which Mr. Walmsley of Springlaw, then acting for Maranello, wrote to Mr. Brooks following a discussion at which it was agreed that, subject to funding, Bonhams would take over the deal. And the deal which was to be taken over, he was confirming that Springlaw was instructed in the acquisition, confirm Maranello Rosso has agreed terms with RM Auction, now part of Sotheby's, for the sale of the Maranello Rosso collection, the consignment to RM Auctions, the split of proceeds generated from the auction. The agreed terms are as follows. RM to acquire the 32 Ferraris, the whole collection less the P330 and 38 A-bars from MRL, the aggregate sum of 74 million, and sign the 70 cars for auction in September in London, to pay a deposit of 7.4 million for exchange contract, exchange to be as soon as possible, and completion on the 29th of May in San Marino. Before I go on, I just want to deal with the question of how the cars were going to be bought from the original vendors, and the sale, which had already been agreed and was due for completion on the 29th of May, was to be paid for, and that was dealt with by Mr. Sullivan in paragraph 38 of his statement on page 191, that it was effectively a back-to-back sale. So what was going to happen, because Maranello Rosso did not have the money back in common ground to actually buy the cars in the first place, RM were going to provide the cash which would enable Maranello to buy the collection, and then there would immediately be a back-to-back sale by which they were sold to RM. And this agreement as set out in paragraphs A to D, before we get on to the next part of the agreement, was an agreement which effectively transferred the risk from Maranello to RM, because RM was buying the cars for 74 million. They'd pay for transport, so Maranello would pay for transport, commissioning. RM would pay the auction costs and would auction the cars with a buyer's premium of 12%, which was payable to them. Insurance. They would get a fee equal to interest of 4% per annum on 74 million purchase price. All cars under 1 million to be sold without reserve. All other cars to have agreed reserve prices. And then the hammer price proceeds. First 80 million to be paid to RM. So in other words, RM get a profit out of the proceeds of 6 million. Then they get 4% per annum interest charge, and all the rest it goes to MRL. And once 80 million plus interest has been paid, title to all the unsold cars would automatically be transferred back to MRL for £1. If the proceeds were less than 80 million plus interest, MRL had an option to buy back cars at a price equal to the shortfall. Once they'd exchanged contracts, MRL would pay a break fee of $5 million. So that agreement, as referred to by Mr. Walmsley, confirming it to be correct, was an agreement which transferred the risk across to the auction house, so that Maranello knew that the money it paid out to acquire the collection would be reimbursed, and that they would then get a profit share. That is obviously a highly advantageous deal. The response to it by Mr. McLean, we can see at page 10 shows us that that letter was sent to Mr. Brooks and Mr. McLean on the 21st of May, following the meeting that day. The next day, 22nd of May, Mr. McLean writes, in terms we see at page 9, further to your meeting with Mr. Brooks yesterday and to our phone conversation this afternoon, I confirm that 1, a member of the Lumen Group will make funds available, subject to contract, to your client MRL to assist in acquiring the entire issued share capital of Stellapar. So that's making available the money for the purchase. Exactly on one construction, the same as RM were going to do. Somebody had to put the money up, give it to Maranello so that they could complete the purchase which they'd entered into the contract to complete on the 29th of May. 2, Bonhams will sell the 70 Ferraris and Abarths by public auction at the Goodwood Revival in September 2014, or on or at such other dates as may be agreed between Maranello, Bonhams and LG. The transaction is to be substantially on the terms set out in your letter to Robert Brooks, attached your email to him and to me yesterday. Now, Lord, when one just pauses there, when you have an agreement which shows a transfer of risk and a purchase, but is preceded by funding as part of the suite of arrangements, and you are told the transaction is to be substantially on the terms set out in the letter to Mr. Brooks, it is in my submission impossible from that, as a matter of construction without evidence, to conclude that what was being said and intended to be understood by this letter was that there was always going to be purely a loan from Lohomij or the Lumen Group, which was to remain a loan throughout the process of marketing and selling and auctioning the cars, so that the risk would remain throughout with Maranello. It is a completely different beast. Now, of course, that may be what would be established on the evidence at trial. But this statement that the transaction is substantially on the terms set out in your letter cannot be consistent with a conclusion that we're not going to buy them, we're going to charge you interest from day one, not out of the proceeds, we're going to charge you a large fee on day one, and the risk will always remain with you. So, when we come to the judge's narrative, that's important. The letter, of course, goes on, which makes this subject to confirmation by return, as agreed in principle on the phone call, that MRLs received an offer, not subject to any conditions. With immediate effect, Lumen Group and Bonhams had exclusive worldwide rights on this transaction, and without prejudice to that, neither Maranello nor Mr. Sullivan will enter into any discussion or negotiate with anyone other than Lumen Group and Bonhams in relation to the transaction, will immediately discontinue any discussions or negotiations in relation to this transaction with RM Auctions or any associated person or entity. So that was saying that we will get exclusivity, you will abandon your negotiations with RM, and effectively this will become a one-horse race. Now, is this a contract for the purchase of the cars? Clearly not. Is this more than agreement to agree? That's a matter of trial. Is there here a representation that in exchange for the exclusivity which they require, they will act in good faith to promote this outcome in the way they've said in my submission? Yes. Now, that's what was came back. There was then at page 8 confirmation from Mr. Walmsley that the RM deal was there, and again, go back to page 7, some additional wording is required. Confirm neither MRL nor Graham Sullivan or any person or entity will enter into a discussion or negotiate with anyone other than Lumen Group and Bonhams in relation to this transaction. So, by this stage, my client agreed with Bonhams that they would tie themselves down and give them exclusivity. It's convenient to deal with, because we're looking at the documents, a matter on which the judge placed considerable weight, which is an email chain which we can pick up at the bottom of page 12, where Mr. Walmsley yes, Mr. Walmsley at 9:48 page. Yes, 9:48 p.m. About a share transfer deed. Was sending it on to Mr. Koppel at Jones Bay. At page 13, Evershed sent the Italian version of the deed. And then 11:26 that evening, so having received the deed, he says at page 11, in terms of structure, we met on Friday. We were discussing a sale of the cars to your client. Now we're dealing with a loan. I probably need to fill in a couple of further gaps, just in case we did not cover anything. So the learned judge said, well, it isn't the case that the first you heard about it was on the evening of 28th of May, because here is this exchange where Mr. Walmsley seems to be accepting there is a change to a loan. Mr. Walmsley deals with this in his witness statement when he says, a second witness statement, and shown it, when he said this was a suggestion, took my client's instructions, said no, heard nothing more about it, and it was only when they were actually about to sign that they were provided with the confirmation that Mr. Luman and Lohomij were indeed insisting that it should be a loan. But of course what this demonstrates is that it was a sale of the cars to your clients which were being discussed. So when one goes back to the spring, to the confirmation from Mr. McLean, which we looked at page 9, transaction substantial in terms of your letter to Mr. Brooks, that is a sale, not a loan. Now, it's, I think, convenient at this stage to go to the judgment, background documents, and we can pick it up at tab 11, bottom page 198. And paragraph 29, the learned judge said, Mr. MRL's case in April 2014, Mr. Luman made efforts to purchase the collection, was unable to do so because of Maranello's exclusive option. This is said to be relevant to the investigation of various defendants in what followed. Then he refers to the sale and purchase agreement, €2 million deposit, 78 million euros to be due by the 29th of May, finance not yet in place. Then 31, Maranello said bonds with his preferred auction house, but its negotiation with Bonds stalled because, unlike RM, Bonds was unwilling to purchase the collection from MRL and seller's owner dividing the profit. And 19th of May, agreement in principle with RM for a back-to-back transaction, just identified. Then followed further discussions. And then MRL's case that Mr. Brooks initiated those discussions, we learned the agreement MRL had reached with RM. 21st of May, meeting between Sullivan, Hilder and Walmsley, and Brooks and McLean on behalf of Bonds. Particular claim do not allege any agreement was reached at this meeting. According to Mr. Sullivan, Mr. Brooks agreed in principle to match RM's terms. Said he'd need to confirm that Bonds could get the funds to buy the cars. Mr. Walmsley's evidence is to the same effect, though he only says that Mr. Brooks said he had to confirm to get the funding. Precise fact cannot be determined on this application. Silence particulars regarding agreements are important. First, MRL's case does not rest on oral agreement on 21st of May. Second, more important, when construing an application to when construing what is said to be an agreement comprising the text of a subsequent email, the court on the application to strike out the claim neither required nor permitted to interpret it in light of any alleged oral agreement. No reliance on any such agreements forming part of the factual matrix. Then we get the letter, then over the page, he sets out Mr. McLean's email, and then on page 201, paragraph 36, Mr. Walmsley's first witness statement says he understood the 22nd of May email to mean, while there may be some negotiation around the detail and specific terms of the agreement, key commercial terms would remain the same, i.e., Bonhams would purchase the collection, would auction the collection at a single auction in or around London. Any sale proceeds over 80 million would be paid to MRL. And then, whatever Mr. Walmsley's understanding of the 22nd of May email, it does not say what Mr. Walmsley says he understood it to mean, that Bonhams would purchase the collection and auction it. It says that a member of the Lumen Group would make funds available to MRL to buy the shareholding of Stella, then Bonhams would sell Stellabar's collection. Perhaps the parties were at that stage cross, perhaps they cannot resolve the question, but the meaning of the email is clear. So the learned judge, without evidence, without disclosure, without evidence being heard, concludes that a reference to the money being provided by a member of the Lumen Group means this was not intended to be a sale, despite the fact that advance of money to enable the purchase to take place was always part of the structure. Then we get the quotes which we've just looked at, page paragraph 37, over the page 202, 38. MRL says, in accordance with the terms of Mr. Walmsley's confirmation, it informs RM it no longer wished to contract with it on the terms previously agreed in principle, broke off discussions with RM. Its case is by giving or acting on the required confirmation, it made what it calls the exclusivity agreement, whereby Bonhams and Lumen Group had exclusivity over those transactions upon substantially the terms that MRL had previously agreed with RM. Communications continued. In his second witness statement, Mr. Walmsley produced a number of emails. One of them sent to Mr. McLean and copied to Mr. Brooks set out summary proposed transaction steps. These included, after completion of the SBA, MRL shall then transfer title to the 70 cars to LG on the agreed terms. This supports Mr. Walmsley's contention that at this stage he was proceeding on the basis the collection would be acquired from MRL. It's contrary, however, to the pleaded case that the agreement was that Bonhams would purchase the collection. Lord, yes, there is a difference, but of course we're talking about an email sent on behalf of Bonhams and the Lumen Group. The identity of the purchaser, less important in my submission than the fact that Bonhams was arranging for the purchase, for the collection to be purchased, rather than simply arranging a loan. Then the email which I read you, over the page, paragraph 41, in his second witness statement, Mr. Walmsley states he sent that email after a conversation with Mr. Coppell on the evening of Sunday, 25th of May. Then for the first time, Coppell said he'd been instructed to work on the basis of a loan. Mr. Walmsley stated he replied this was contrary to what had previously been discussed and agreed. Change this to reflect his email. He first spoke to Mr. Sullivan on the 26th. Very clear in his rejection. Mr. Sullivan's second witness statement has the same effect. In this regard, I make the following observations. The first witness statements of Mr. Sullivan and Mr. Walmsley more clearly indicate parties were proceeding on the basis of a purchase by Bonhams, not a loan by Lohomij, until the question of the loan was raised on 27th of May. In his second statement, Mr. Walmsley maintained to say that in terms, the question of a loan was first raised on the 27th of May 2014. That's correct. It was a plain implication of the witness statements. It was a claim. The second one was produced because Mr. McLean drew attention to the email. Mr. Walmsley's evidence that his email to Mr. Coppell was in response to a conversation in which for the first time a loan had been mentioned, and a conversation in which he responded to the loan was contrary to what had been agreed, is plainly wrong. First, the email raised no objection to proposals contrary to what had previously been agreed, nor does it say anything about needing to speak to Mr. Sullivan, although the proposal is now said to affect a fundamental aspect of the transaction. Mr. Walmsley said he didn't discuss the matter with Mr. Sullivan the following day. Secondly, he's copied to Mr. Mark Henry in Burkitt. Mr. Walmsley couldn't possibly have copied the third party of his email. In the second instance, he now says he remembers them to have been made. Need to get client's instructions first. Third, the final paragraph makes clear that Mr. Henry was already involved his own client in respect to the security of documentation. It is simply incredible, therefore, that Mr. Walmsley was first presented with a suggestion of a loan in a conversation on the 25th of May 2014. So, this is the learned judge at a summary judgment strikeout application, where there is evidence from a solicitor, Mr. Walmsley, to the effect that that was precisely the case, reaching a conclusion based on his reading of the documents and dismissing as effectively untrue the evidence of Mr. Walmsley about it being tested. We can just go on and finish this section. Meeting in Milan. On the afternoon of the previous day, Mr. McLean sent an email to Mr. Lumen setting out a summary of the deal as it looks at present. And this is where we get the comment. On completion of the agreement, the Lohomij Group will lend approximately 86 million, so MRL, which will use the loan to pay for the shares of Stella Bar and stamp duty and related costs. So far, all as expected. Stella Bar will sell the cars to MRL for 65 million, which will be left outstanding as a debt from MRL to Stella Bar. There we have the change to loan. On completion, MRL will consign the cars to bonds for sale at the revival, or maybe some cars at Quail Lodge in August. Learned judge, having looked at that, says Mr. Sullivan stated you can see the email to disclosure, probably correct, contains entirely contrary to what had been agreed. However, I make the following observation. The structure of the transaction described in this email is consistent with the 22nd of May email. Now, lady, lords, just pausing there. I've shown you the 22nd of May email. I've shown you how it says substantially on the terms of the RM offer, which is an offer to purchase and transfer risk. So for the learned judge to say that this internal communication between McLean and Lumen was consistent with 22nd May email is a conclusion which, in my submission, the judge cannot properly reach without proper disclosure and proper testing of evidence. The fact a loan rather than a purchase is reflected in Mr. Walmsley's email of 25th of May. Yes, that is part of the story. Mr. McLean's email records the scheme had been considered by professional advisors instructed by MRL. Scarcely credible Mr. McLean would tell Mr. Lumen it had been so considered. It hadn't been, especially if they were conspirators. This is drawing an awful lot of inferences. Scarcely credible that Bonham or Lohomij could envisage a transaction of this sort concerning overseas companies could have proceeded unless MRL had had a chance to take proper advice on the matter. Scarcely credible that a meeting with MRL's lawyers in Milan would have been arranged to discuss a transaction different from that on which those lawyers had been instructed. Further point made by Mr. Weeks' email between these supposed conspirators directly contrary to PD's case. Paragraph 107 identifies the first purpose of the conspiracy that existed from at least May 2014 being to auction 10 cars in California. Yet the second numbered paragraph is inconsistent with a conspiracy of that purpose. Of course, the second numbered paragraph has, in brackets, maybe some cars at Quail Lodge in August, which is, of course, something that had never been mentioned to my clients, was never mentioned to them until the 30th of June. Nevertheless, MRL's case, at least to the second statement, was only on the 27th of May, at a meeting at Rimini, that Mr. McLean informed MRL that Lohomij's preference was to lend money to MRL to complete the SPA rather than to fund Bonham's acquisition. Sullivan said I immediately refused his suggestion. In my view, it will not do to say that we have a conflict of evidence as to the course of events. MRL's case as to the the circumstance in which a loan was first mooted makes no sense on its own terms and is incredible in the light of the documents. Of course, it's important never to lose sight of the fact, however the proposal to deal with matters by a loan first arose, MRL did in fact agree with it. Now, Lords, there is plainly a conflict of evidence where it is said by the defendant that there was never any question of a purchase. That's a pleaded case, it was always a loan. When we have the references to purchase in the steps planned by Mr. Walmsley, when we have the 22nd of May letter specifically referring to a purchase, when we have Mr. Walmsley's first retort to the suggestion of a loan. These are all matters which a judge will determine at trial when there's been disclosure and the evidence has been tested, to determine it summarily and to conclude, as the learned judge in effect did, that Mr. Walmsley was not telling the truth when his evidence has not been tested. And to do it in these terms, incredible, is something which is, in my respectful submission, not open to a court properly exercising its function under summary judgment. I added to the authority just to remind us, and Lord Justice Arnold will be familiar with this, at tab 33, which is at the end of volume 3.
I'm sorry, tab 33.
Of the authorities bundle,
Thank
volume
you.
3, which I hope has been sent to the bundle. And we can, in this case, Krieva against Bedsamov, and we can pick out just a point of principle, paragraph 34 on page 614. Mr. Fenwick cited a number of cases show there are only limited circumstances which a court can dismiss evidence given by affidavit or witness statement without the witness being cross-examined. And then suffice a quote from Coyne, where Lord Justice Reimer accepted its well-settled practice. The court finds itself faced with conflicting statements, affidavit evidence, usually in no position to resolve them, to make findings as to the disputed facts without first having the benefit of cross-examination of the witnesses, nor would it ordinarily attempt to do so. Basic principle is that until there's been such cross-examination, it is ordinarily not possible for the court to disbelieve the word of the witness in his affidavit will not do so. Not an inflexible principle may in certain circumstances be open to the court to reject an untested piece of such evidence on the basis manifestly incredible, either because it's inherently so, or because it's shown to be so by other facts that are admitted or by reliable documents. Counsel said these principles apply equally to cases in which evidence is given by witness statement rather than by affidavit. I agree. I said as much in my summary of the principles in Long and Farrar, and it applied in this case where Mr. Justice Snowden had disregarded without testing evidence which was made by way of a witness statement. And I say that because the court would have to be persuaded that somehow a statement we will proceed on substantially the same terms as RM, namely a purchase, was not such a suggestion at all. And that the whole structure of the deal was determined not by that, but by the reference that a member of the Lumen Group will advance a fund in circumstances where, as I've indicated and shown, it was always the case that a somebody would have to advance the funds in the first place, because you can't, unless you buy from Stella for whatever it is, 68 million euros, then you can't complete the transaction. So you need the cash first, and somebody has to advance it. If it proceed on substantially the same terms, that envisages a sale. Now, I can't persuade this court that they agreed there was a sale, because we don't have the evidence. But nor can it, in my respectful submission, be correct for a judge dealing with a summary judgment application on this basis, with that kind of evidence from Mr. Walmsley and from Mr. Sullivan and Mr. Phillips, conclude that there was never any question of a purchase. Because that's what the judge has found. And that effectively goes to the root, when we come to look at fiduciary duty and breach of duty of good faith, the judge, and when the judge approached the whole question of settlement, he had already rejected in this way, in my submission impermissibly, the case as presented. Of course, if it's just an ordinary case, oh yes, it was only ever going to be a loan, then everything else may fall into place. It's only going to be a loan, it is a loan, and then there is a commercial agreement.
The real thrust of this case, isn't it, is that you were forced to enter into the agreements on the 29th and 30th by duress. Economic duress.
Economic necessity, yes. We were there. They changed the deal. That was Mr. Luhmann saying, I now want it to be a loan. That's our evidence. When, having abandoned RM, and therefore lost that route because we entered into the exclusivity arrangement, to put it neutrally, we had no other economic option than to do so. That could be hard business. Absent evidence in the form of Mr. McLean's statement that there was a conspiracy here all along, it could be treated as nothing dishonest, hard practice, tough, hard-nosed practice, change of mind. Of course, if the intention had always been, as the learned judge was pressed to find, that there was only going to be a loan, then to have said on the 22nd of May, we will enter into a transaction on substantially the same terms so long as you abandon RM, would itself have been dishonest.
But you've not applied, set aside this agreement,
No.
either on the basis that they were induced by fraudulent misrepresentations or that they were procured by duress. Those agreements remain binding and in force.
Yes, and of course we couldn't have undone them. I mean, with the money which came from the loan, which came from the 29th of May, loan agreement, the collection was bought, half of it had been sold, or most of it had been sold by the time of the settlement agreement. So the die was cast. There was no option open to us at that stage.
It must not be the contention that that agreement was procured by duress, must be something that was settled by the settlement agreement.
That it was procured by commercial pressure, yes. I don't want there to be any doubt what I'm accepting. We'll have to look in a moment at the settlement agreement as against the claim which was being made.
Well, your clients plainly knew when they entered into these agreements, on your case now, this is not what they wanted.
Yes.
And they must have said so, presumably in strident terms, in
Yeah.
correspondence you'll show us, and say we're signing these under protest.
Either way, we don't want to do this.
And so all those claims must have been settled because it's plainly within. You knew all about them. You've known about them right from then.
Yes, but of course there's no cause of action which arises. You say the claim is settled. No cause of action would normally arise out of somebody who is not contractually bound to you, which is Lumen, because the agreement, if there was an agreement, the exclusivity is with bonds. Lumen says, well, I'm not going to lend to you and then either buy myself or fund bonds to buy. I'm going to do it. It doesn't in itself give rise to cause of action. It does give rise to cause of action as part of a conspiracy. But if it is simply hard-nosed commercialism, then I wouldn't be coming to the court below or to this court saying that the decision on that stage was something which was a breach of contract by Lumen or anything else.
But what you have been showing us, as I understand it, the purpose of it has been, first it goes to ground 6, which is this the proper way to behave on a strikeout application in general?
Yes.
And then does the way in which the judge approached this therefore infect the other grounds of appeal? And that's why you've been taking us to this,
yes,
rather than any specific duress point or anything like that.
Exactly that. It's a very good, without going down into any other weed, because this is part of his reasoning when you come to fiduciary duty and duty of good faith, it's convenient to take here. It is a clear illustration of something the judge did many, many times in this case, which is to approach his task in the task of a fact-finding tribunal rather than a court assessing a summary judgment application. And in fairness to him, he was encouraged endlessly by the defendants for days and days that he should do this, and he should look at all the facts and reach conclusions on every single fact available to him. I wanted to use that as an introduction before going to see what the judge dealt with in terms of the authorities. And again, we've got 3 bundles of authorities, but most of it is in here in the judgment. And I'm not going to take you to endless authorities, except to the extent I think it's really going to assist the court. If I may, I'm going to take you through the judge's reasoning on construction, and then explain why we say he's got it wrong. And it starts at page 224, the judgment, paragraph 84, section. And paragraph 84 summarizes the issue. Defendants say everything's covered. We say didn't release any claims of dishonesty, fraud, or conspiracy. So that the claims of conspiracy, fraudulent misrepresentation, breach of fiduciary duty, duty of good faith, dishonest assistance have not been released, nor subsequent claims. So he recites Lord Bingham Dairy Containers, Justice Carr in ABC Electrification, and picking it up on page 225 in Roman 1. That's Roman 1. That meaning has to be assessed in the light of the national ordinary meaning of the clause, any other relevant provision of the contract, overall purpose of the clause, fact and circumstance known or assumed by the party at the time the document was executed, and commercial common sense, but disregarding subjective evidence of any party's intentions. Clear, lucid exposure. He then goes to BCCI and Ali, paragraph 87, page 226. And of course, that was, as the court knows only too well, when neither side knew of the existence of a claim for stigma damages. And the question was whether a comprehensive settlement was intended to give is relevant both to construction and to the sharp practice principle. On page 227, the quote from paragraph 9 of Lord Bingham's speech, party may at any rate a compromise agreement supported by valuable consideration agree to release claims or rights of which he is unaware, which he could not be aware, even claims which could not on the facts known to the parties have been mentioned, if appropriate language is used to make plain that's his intention. Both good law and good sense. No part of the court's function to frustrate the intentions of the contracting parties once he has been objectively ascertained. But a long and, in my view, salutary line of authority shows in the absence of clear language, the court will be very slow to infer the party intended to surrender rights and claims of which he was unaware and could not have been aware. And that, we say, is important, and the judge effectively didn't give a sufficient weight to it. And then we get the comment at the bottom of that page. I think the authority justify the proposition of answer paragraph 10 above and provide not a rule of law but a cautionary principle to inform the approach of the court to construction instruments such as this. I accept, as Hoffman forcefully points out, the authorities must be read in the context of the facts. Judges, I quote, express themselves in terms more general than was necessary for the decision of the instant case. I share their reluctance to infer that a party intended to give up something which neither he nor the other party knew or could know that he had. And then he dealt with a particular case of stigma damages, where nobody could have thought that such a claim existed. On a fair construction of the document, 8 lines down, I cannot conclude the parties intend to provide for the release of rights and surrender of claims, which they could never have had in contemplation at all. If the parties sought to achieve so extravagant a result, they should have used language which left no room for doubt. And then we get Lord Nichols in relation to the cautionary principle. If we go on page 229, just in paragraph 28, approach should not be pressed too far. It doesn't mean once a possibility of further claims has been foreseen. A newly emergent claim will always be regarded as caught by general release, whatever the circumstance in which it arises, and whatever its subject matter may be. However widely drawn the language, the circumstance in which the release was given may suggest, frequently they do suggest, that the parties intended, or more precisely the parties are reasonably to be taken to intended, that the release should apply only to claims known or unknown relating to a particular subject matter. Now, the Learned Judge, I think, grabbed hold of that, and also the decision in the Chengiz case to say, well, because of the wording of the release, that's all right. But that's not quite what is said by Lord Nichols. The court has to consider what type of claims at which the release was directed. For instance, depending on the circumstance, of mutual general release on supplement final partnership might properly be interpreted as confined to claims arising in connection with the partnership business. It couldn't be taken to include a claim about encroaching tree roots. Then we have Lord Bingham, and I just want to go on because I know the court will be very familiar with this, having read it 232 in paragraph 90, where he picks up what Lord Hoffman says that on principle of law like this, it's dealing with sharp practice, I think it's legitimate to go back to authority. Lord Keeper Henley, where he said no rule is better established, every deed obtained on suggestio falsi, suppressio veri, is an imposition before the conscience. In principle, therefore, I agree with what I consider Sir Richard Scott to have meant. His passage of paragraph 30 of the judgment, which I quoted, Lord Justice Chadwick, a person cannot be allowed to rely upon release in general terms. He knew the other party had a claim, he knew the other party was not aware that he had a claim. I do not propose any wider principle, because obviously a woman dealing with the market legitimately taking advantage of the known ignorance of the other party, but both on principle and authority, I think a release of rights is a situation which the court should not allow parties to do so. On the other hand, if context shows the parties intended for a general release of good consideration, rights unknown to them, I can see nothing unfair. It follows, in my opinion, that the principal party to a general release cannot take advantage of a suggestio falsi, expressio veri, in other words, what would ordinarily be regarded as sharp practice, is sufficient to deal with any unfairness which may be caused by such releases. There is no need to try to fill a gap by giving them an artificial construction. And then he draws a number of principles from that. Very special principles of construction, cautionary principle, not a principle of law, useful distillation of judicial wisdom, and he paraphrased it, paragraph 4 here. If a party, plain meaning of a release would appear to indicate a party was agreeing to give up rights of action of which he was not aware, and of which he could not reasonably have been aware, the court, before concluding that that is indeed what the release does mean, ought to pause and ask itself whether that is really what the release means, and carefully examine the context, see whether the words more appropriately bear some more restrictive meaning. In reaching its decision, however, the court will find normal principles of construction, not specifically restrictive ones. If the cautionary principle were to mean more than this, assuming the stated principle of law. As there are no special principles of construction applicable to releases, that private knowledge held by one party to a release but not by the other parties is irrelevant to the interpretation of the release. Well, it depends what the learned judge meant by that. If party A, here Bonhams and Lohomij, know they have been acting pursuant to a conspiracy, that cannot widen the terms of the settlement, nor does the fact that they know of it mean that the clause should be given a wider construction than is warranted on its face and on the factual matrix. He then goes on to look at Maranello, and that was the question of whether the release extends to fraud claims, and then it's Lord Justice Morvick, and I want to pick up what he says in paragraph 234, relevant.
Sorry, 234,
Page 234, I'm sorry,
yeah.
Paragraph 209.
Yes.
Mr. Kendrick submitted the parties cannot intend to compromise claims misrepresentation for each one based on fraud, both because of the fact they were granted fraud and because they were claims whose existence was unknown at the time. My view, having regard to the context in which the parties entered into the settlement agreement, the language in which they expressed themselves, it was their intention Western Star should be discharged from any further liability under Section 4.1 of the SPA, whether the possibility of a claim was known to MN at the time or not. Claims more unknown. I am satisfied. I find it more difficult to say they intended to release Western Star from liability for claims arising out of its own fraud, however. I am satisfied neither party had the possibility of fraud in mind. As Lord Justice Rick said in HIH, fraud is a thing apart, as parties contract with one another in expectation of honest dealing. Moreover, the manner in which fraud is treated in Article 12 reinforces the conclusion the parties in this case regard as giving rise to fundamentally different considerations. If therefore Mr. Ellis's knowledge is to be imputed to Western Star, so as to render any representation of any fraudulent, I do not think the settlement agreement was intended to deprive Maranello of his right to pursue a claim respectively. I regard those as being consistent with the conclusions I draw from BCC Alley. They make a further point in respect to fraud, which I understand as follows. The question whether release of claims is yet unknown extends to claims based on fraud is to be answered according to the normal principles of contractual interpretation. The fact that parties generally contract with one another in expectation of honest dealing does not introduce a new principle of construction. It may be a matter to be taken into account as part of the context of the contract containing the release, and as such may affect its interpretation according to normal principles. Well, Lord, with respect, the learned judge is rather watering down what is clearly stated by Lord Justice Morvick. And if we go to Satyam, paragraph 95, Court of Appeal concerned whether claims arose out of a service agreement which was subject to release or out of a different contract. Then Lord Justice Lawrence Collins, with whom the others agreed, went on to consider obiter whether the release would apply to unknown claims that arose after the date of settlement agreement and to unknown claims involving allegations of fraud. Referred to BCCI and Alley and Mann and the position of Justice Flood at first instance, and continued. I do not accept the submission. That was that it must have been intended to compromise fraud-based claims. I would agree the exclusion clause cases should not be automatically imported into the area of releases. That's not what Lord Justice Morbick did in Mann or Mr. Justice Flow did in the present case. Court will be very slow to infer that a party intended to surrender rights and claims of which he was unaware could not have been aware. Seems to me clear the same principle must apply to fraud-based claims. If a party seeking a release asks the other party to confirm, it would apply to claims based on fraud. It would not, in most cases, be difficult to anticipate the answer. He then went on, paragraph 96, Judge, to say, much be gained from the suggestion the exercise better conducted concretely by reference to claims and in the abstract. Yes. Reject the submission that there's a principle of law that express words are required for release of either unknown claims or claims in fraud. But you have to look at the circumstances. He then deals with Brazier. That was a case in which there was phone hacking and a second claim in phone hacking, and that really is very different from our case. And I think we can go past Marsden. Was a case, of course, in which Mr. Marsden had raised allegations of misconduct in the outset. And I'm going to go on to 241, paragraph 103, where we get Cengiz and Grant Thornton. And in this case, of course, Mr. Justice Knowles concluded, as we see at bottom paragraph 103, that the reasoning in BCDCI and Satya led him to conclude the settlement agreement in the case before him, released unknown claims in fraud. Essentially, the reason for that was that the claims, really taking this shortly, were claims in which we're dealing with the SFO, paragraph 43. In the subject area of investigation or action by the SFO, an allegation of misconduct or deliberate wrongdoing would be what objectively the parties would have in contemplation as likely to be asserted in any attempt to ground a claim against Counting or Mr. Johansson. So the very fact that it was in the area of investigation by the SFO, allegation of deliberate wrongdoing would be precisely what the parties would have in mind. So when one looks at that, it should, in my submission, have led the judge to conclude that there must be something either in the express wording of the settlement agreement or in the surrounding circumstances known to both parties, which meant that the court can reasonably infer that claims in fraud and conspiracy were envisaged and intended to be covered before the exclusion would extend to it. He then quotes Mr. Knowles on sharp practice, the next one I want to go to briefly, I see the time is...
You added in the word conspiracy there, but is there any, do any of the authorities, when discussing fraud, extend it to conspiracy as well?
I don't think so in terms, and of course, they all deal with fraud and deliberate wrongdoing, and conspiracy here, which involves lies and deliberate intention to injure, is in my submission in the same category as that. I think we said we would break the shorthand writers at 12. So when I just mention the reference to Justice Mulder in UCOS, which has as a last proposition, general release without disclosing the existence of a known claim could be unacceptable if the law would be defective if it did not provide a remedy. So,
where were you reading from?
I'm reading from the top of page 245.
Thank you.
Third quote from Mr. Justice Mulder.
Thank you.
I'm going to now move on from the law to what the judge did with it. I wonder if that's a convenient moment for our break.
Thank you very much indeed. I'm not sure how long the break has been agreed to be.
I don't know. I mean, either 5 or 10 minutes, I assume.
10. Okay, so we'll resume at 5 to 12. Mr. Fenwick, I'm also a bit concerned about progress generally, so perhaps you think about that too.
I think I'm all right, lady, but I will say.
Okay. All rise.
Stolen for try and come back with an arms.
Yes, yes.
No, we'll just put just the live stream.
Take it as
You added the word conspiracy to all the